Welcome to the Corporate Compliance Tip. Today is an overview, what prosecutors do when evaluating your corporate compliance program. This is presented by the American Institute of Healthcare Compliance. The content of this compliance tip should not be considered as legal or consulting advice. In April of 2019, the United States Department of Justice Criminal Division updated their evaluation of corporate compliance programs guidance document. When potential wrongdoing is being investigated, prosecutors must consider whether the corporation has made significant investments in and improvements to its corporate compliance program and internal control systems. The United States Sentencing Guidelines advise that consideration be given to whether the corporation had in place at the time of the misconduct an effective compliance program for purposes of calculating the appropriate organizational criminal fine. This document provides guidelines to assist prosecutors in making informed decisions as to whether and to what extent the corporation's compliance program was effective at the time of the offense and is effective at the time of a charging decision or resolution for the purposes of determining the appropriate form of any resolution or prosecution, monetary penalty, if any, and compliance obligations contained in any corporate criminal resolution. The Justice Manual is referenced throughout the guidance document. I'd like to review Section 928.800. Compliance programs are established by corporate management to prevent and detect misconduct and to ensure that corporate activities are conducted in accordance with applicable criminal and civil laws, regulations, and rules for healthcare providers. Now, the department encourages such corporate self-policing, including voluntary disclosures to the government of any problems that a corporation discovers on its own. Just because your healthcare organization has a written compliance program, that alone is not sufficient and of itself to justify not charging a corporation for criminal misconduct undertaken by its officers, directors, employees, or agents. In addition, the nature of some crimes, such as antitrust violations, may be such that national law enforcement policies mandate prosecutions of corporations, and notwithstanding the existence of a compliance program. The government recognizes that no compliance program can ever prevent all criminal activity by a corporation's employees. However, there are some critical factors to evaluate whether the program is adequately designed for maximum effectiveness and to prevent and detect wrongdoing by employees, and whether corporation management is enforcing the program or is tactically discouraging or pressuring employees to engage in misconduct to achieve business objectives. Now, the Justice Manual also states additional questions the prosecutor should ask, such as, is the corporation's compliance program well designed? Is the program being applied earnestly and in good faith? And does the corporation's compliance program actually work? And these are topics of additional compliance tips that I'm hoping that you will also watch. So to answer these questions, the prosecutor is directed to consider the comprehensiveness of the compliance program, extent and pervasiveness of the criminal misconduct, how many and what level of corporate employees are involved, the seriousness, duration, and frequency of the misconduct, promptness of any disclosure of wrongdoing to the government, and any remedial actions taken by the corporation, which could include, for example, disciplinary action against past violators uncovered by the prior compliance program, and revisions to corporate compliance programs in light of lessons learned. When evaluating compliance programs, prosecutors are asked to consider whether the corporation has established corporate governance mechanisms that can effectively detect and prevent misconduct. For example, do the corporation's directors exercise independent review over proposed corporate actions rather than unquestionably ratifying officers' recommendations? Are internal audit functions conducted at a level sufficient to ensure their independence and accuracy? Have the directors established an information and reporting system in the organization's reasonably designed program which should provide management and directors with timely and accurate information sufficient to allow them to reach an informed decision regarding the organization's compliance with the law. In other words, the prosecutors are asked to determine whether the corporate compliance program is merely on paper versus thoroughly being designed, implemented, reviewed, revised as appropriate and in an effective manner. Prosecutors are going to review your organization to determine whether you have staff sufficient to audit, document, analyze, and utilize the results of the corporation's compliance efforts. Prosecutors also should determine whether the corporation's employees are adequately informed about the compliance program and are convinced of the corporation's commitment to it. The Department of Justice states this will enable the prosecutor to make an informed decision as to whether the corporation has adopted and implemented a truly effective compliance program that, when consistent with other federal law enforcement policies, may result in a decision to charge only the corporation's employees and agents or to mitigate charges or sanctions against the corporation as well. Because a corporate compliance program must be evaluated in the specific context of a criminal investigation, the DOJ's Criminal Division does apply any rigid formulas to assess the effectiveness of corporate compliance programs. The DOJ recognizes that each company's risk profile and solutions to reduce its risks warrant particularized evaluation. Thus, accordingly, the DOJ is going to make individual determination in each case. There are, however, common questions that they may ask in the course of making an individualized determination. When was the last time your C-suite executives and board of directors reviewed the effectiveness of your compliance program? Now may be a really good time. I'd like for you to learn more about the Corporate Compliance Officer web-based training course and become a certified compliance officer through the American Institute of Healthcare Compliance, or visit our website for more information.